Good evening, everyone. First of all, sorry for the delay to start the program because few of our participants they requested to wait for some time. That's why we have delayed the program. Good evening, everyone. I am Veena, Secretary of this Federation of Telangana Chambers of Commerce and Industry. On behalf of the Federation, I extend a warm welcome to each one of you to today's awareness program on the newly enacted Criminal Major Acts, BNS, BNSS, and BSA 2024. Before we begin the formal proceedings, let us take a moment to watch a short film that captures the legacy, vision, and service of FTCCI, one of India's oldest and most respected industry chambers, now in its 108th year. I request Mr. Venkat to play the film.
1917, year when a dedicated organization, the Deccan Chamber of Commerce, was formed to encourage trade and commerce activities. The historical journey of the organization has witnessed great transformation as per the changing needs of the industry and businesses. Federation of Telangana Chambers of Commerce and Industry, FTCCI, a legacy of excellence, voice of the industry, representing interests of over 25,000 businesses, all sizes, sectors, and regions, is empowering industry and trade of Telangana state. Leader in pharma, a global hub for vaccine, home to all major MNCs, leader in IT exports, an emerging first stop of India. FTCCI advocates a pro-business environment, caters to the needs of MSMEs, budding entrepreneurs, and traders through its advisory services in taxation, market information, industry-related issues, B2B connection. The Chamber has its nominees in the state-level advisory committees to help drive business productivity. FTCCI aids in providing certificate of origin for exporters, issues visa recommendation for business travels. The Federation imparts job skills through its dedicated skill center. It has adopted 14 government ITIs to improve the employability of students. With a uniquely global perspective, the FTCCI events reach a highly engaged audience, policymakers, and stakeholders aiming towards Atmanirbhar Bharat. Come, be a part of this dynamic and proactive organization. Together, let's realize the vision of a progressive future.
Thank you, Venkat. I hope you all enjoy learning about the FTCCI and the wide array of services and platforms we provide for businesses, professionals, and institutions. If you are not yet a member of FTCCI, we invite you to join our growing community, 3,000 plus members, and benefit from our knowledge sessions, networking platforms, policy advocacy, business services, and more. Please visit our website www.ftcci.in to know more about how FTCCI membership can benefit you. We are now ready to begin the formal proceedings of the day. May I request our President, Mr. R. Ravikumar Garu, to present a bouquet to our esteemed guest. Sri Banda Shivananda Prasad Garu, former Advocate General, Telangana and designated Senior Advocate. Sri Nirmal and Sri Nirmal Kumar Pandey Garu, Advocate and former Group General Counsel, TCA Gati Group. As a mark of our appreciation and respect, may I now request our President Sri Ravikumar Garu to kindly deliver his welcome address.
Good evening, one and all. And I also say sorry that we had to wait because of the traffic and rain. A lot of people were requesting. And fortunately, I was happy that it got delayed because I could spend some 15-20 minutes with the guests today who have come, the honored guests. And it's amazing. Yeah, I think what little I could hear from them, and I think all of us will be benefited by it immensely. So today's guest, as you know, Sri Banda Shivanand Prasad Garu, former Advocate General, Telangana and designated senior advocate. Sri Nirmal Kumar Pandey, advocate, former Group General Counsel of TCI Gati Group, Hyderabad. And my colleague, Senior Vice President, Sri K.K. Maheshwari, and the chair and co-chairs and advisors of the corporate law, IBC and ADR, which is under the chairmanship of CA Naresh Gelli, Dr. Tasneem, Ritesh Mittal, and one of our senior past presidents, Raju Garu, who keeps guiding us. Members and special invitees of the corporate law, a very good evening and warm welcome to you all once again. It gives me great pleasure to welcome you to this awareness program on the newly enacted criminal major acts. As you are aware, the Bharatiya Nyaya Sanhita (BNS) and the Bharatiya Nagarik Suraksha Sanhita (BNSS) and the Bharatiya Sakshya Adhiniyam (BSA) 2024, a subject of immense national significance. As you are aware, the Government of India has recently repealed and replaced the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act, marking a landmark shift in the criminal justice framework after nearly 160 years. These legislations are expected to have far-reaching implications for legal practitioners, corporate enforcement agencies, and the general public. At FTCCI, we take the pride in being at the forefront of creating awareness programs and facilitating expert-led discussions on such transformative legal reforms. I must appreciate our corporate law, IBC and ADR committee chair, Naresh Gelli Garu, and his team for curating this focus session today and for bringing together such eminent legal minds to decode the new regime. I extend a warm welcome to our esteemed guests, and I am confident that this evening's discussions will provide rich insights and practical perspectives on how the new criminal laws are poised to transform the delivery of justice in India. With these words, I once again welcome you all and look forward to an engaging and enlightening session ahead. Thank you.
Thank you, sir, for setting the tone for today's event. May I now request CA Naresh Chandra Gelli Garu, Chair Corporate Laws and IBC Committee, to introduce the theme of today's program and deliver his introductory remarks.
Distinguished guests on the dais and off the dais, ladies and gentlemen, it's a both privilege and honor to address you all at this awareness program on the newly enacted criminal major acts, BNS, BNSS, and BSA 2024, the Administration Criminal Justice System in India. Our session today has been thoughtfully designed to provide a comprehensive insight into the objective, scope, implications of these transformative laws. As we all know, the enactment of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam marks the historic departure from colonial stature and represents a bold step towards more just, citizen-centric, and effective criminal justice system in India. As part of this awareness program, our esteemed speakers and subject matter experts also explored the key areas of civil reforms and the summary suits of recovery of receivables in the shortest possible time. This session will include a brief but focused discussion on some of the salient features of this mechanism aimed at ensuring speedy justice and improving the ease of doing business. These sessions also are structured not just to information but also encourage a meaningful dialogue, clarify doubts, and prepare stakeholders across sectors for effective understanding of the Act. We believe that awareness and understandings are the first step towards a meaningful reform. By the end of today's session, we hope each participant walks away with a greater clarity, a deeper appreciation of the spirit behind these legislative changes. Let us embark on this journey of insight and inspiring together. May I now request all the delegates who are available in the hall today to welcome us speakers with a greater round of applause. Thank you, and I look forward for enriching evening today. Thank you.
Thank you, sir. We now begin technical session 1, where we will explore the landmark reforms introduced through the BNS, BNSS and BSA 2024, which have replaced the IPC, CRPC and Indian Evidence Act. We are honored to have with us Sri Banda Shivanand Prasad Garu, former Advocate General of Telangana and designated senior advocate, to guide us through the nuances of these path-breaking changes. May I now request Dr. Taslim Sharifji, our co-chair of this Corporate Law IPC and ADR Committee, to introduce our esteemed speaker for the first technical session, Sri Banda Shivanand Prasad Garu. Thank you.
Good afternoon, everyone. It's my utmost pleasure to introduce Mr. Banda Shivanand Prasad. Today we will be having one of the best sessions where we'll be discussing on repealing the colonial law. As SRK Shah Rukh Khan said, बड़े-बड़े देशों में ऐसे नए कानून आते रहते हैं. So sir will today take us what was 160 years back and what is being changed now. Mr. Banda Shivanand Prasad, known as B.S. Prasad, Senior Advocate, former Advocate General for the state of Telangana, hails from Jangaon, erstwhile Warangal district. He was enrolled as an advocate with the Bar Council of the state of AP on 30th January 1987 and joined the office of his senior, Mr. C. Trivikrama Rao, a renowned advocate of Hyderabad. Ever since from the date of joining his senior and after becoming independent in 1992, he attended before trial courts, several DRTs, DR80, Chennai, Kolkata, High Court and whatnot. There are reported judgments of full bench, division benches of High Court. He appeared as a standing counsel for almost all nationalized banks, private banks, corporates, and also appearing for the banks and companies for the debtors who could not afford to repay on account of business failures beyond their comprehension. Appointed as a special government pleader in 2014 for the state of Telangana and later appointed as Advocate General for the state of Telangana and worked as such quite successfully till December 23. Subsequently, he has been appearing as designate senior counsel before Honorable High Court, Telangana, Andhra Pradesh, and other courts. Requesting sir to come on the dais and take the mic, sir. Over to you, sir. Thank you.
The R. Ravi Kumar, President FTCCI, the Naresh Chandragilli, yes, Tasneem Sharif, and my friend Mr. Nirmal Kumar Pandey, and the participants in this evening of this meet. Ladies and gentlemen, very good evening. Friends, the three enactments which have brought in by the government replacing the old three major acts, that is Indian Penal Code, the Adjective Law, that is the Procedural Law, Criminal Procedure Code, and the Evidence Act, which are quite important in the matter of proof of the eventual guilt to be for which the accused is liable to be punished. Friends, as far as the criminal law is concerned, the substantive law, Indian Penal Code, it is replaced by the Bharatiya Nyaya Sanhita. Friends, the government thought to have these fundamental penal law, that is the Indian Penal Code, to be replaced while retaining the most of the provisions. The government felt it desirable to have some more offences and also to integrate the various other sections of the IPC into a particular chapter so that the relevancy thereof is connected to each of those offences. Friends, essentially, though there is no fundamental change, but the additions made by the central government in this new enactment, that is substantive law. First, I'll deal with, friends, the fundamental changes I will be able to discuss and deliberate. And after this, my view on these three enactments, friends, you can query any question in relation to these enactments or the changes, and wherever, whatever doubt which you have in your mind, you can put a questionnaire to us. I will try to answer. Friends, to bring more efficiency and transparency, the government thought to have this BNS Act to be enforced. Therefore, after due deliberations, after enormous study and the recommendations of the Law Commission, it felt desirable to have certain provisions to be added so as to strengthen the criminal law to be enforced against the errants, against the offenders, in tune with the amended provisions of the Act. Friends, the salient features of the BNS Act, which will come in the aid of the victim, where the state also is equipped with more force, can eventually seek the conviction of an accused. Certain changes which have been brought in, I'll also just place before you for your understanding as to what was the change in the BNS. Friends, the basic aspect as to the streamlining of the BNS Act was the larger section. The IPC used to have 511 sections, and under the BNS, because certain provisions have been consolidated by, they have not deleted, they have consolidated into the main section of BNS. They have brought, my friends, 358 sections were eventually retained in BNS Act, which have been enacted. And certain important aspects of this BNS Act is, friends, this is a community service. Community service, when an offender is found to be guilty of certain offences, which are, the community services are not that much important for the reason that the community service is imposed in respect of the petty offences. But this is one of the important feature where the court can inflict a punishment of community service on account of certain offence committed, which are of course trivial in nature, that may not have that much importance in the major amendments. The offences relating to women have been strengthened in this BNS Act, where a promise, that may not be much relevant to you, but yet I wish to bring it to your notice about this significant change. One of the changes is that where a woman is promised to for marriage, and if it results in breach, the offense for which the person who has breached the promise will be dealt with under the penal law now in a rigorous way. Now, snatching, where the woman is going on the street, someone snatches. That was not specifically indicated in the IPC as to what particular offense is attracted to prosecute and punish that accused. Now that snatching was also made specifically as an offense. Friends, certain other offenses relating to the certain persons, where the offenses against certain minor 15 years of under 15 years, above 60 years, the police have to go to them and inquire, interrogate, and investigate into the cases. That also may not be that much relevant. Friends, one of the important offense which has been defined, where that is in relation to sections 111 and 113 of BNS Act, that is organized crime and terrorist acts, which was not there, because as far as the terrorist acts are concerned, that was brought in under Unlawful Activities and Prevention of Activities Act. Now, under this IPC, the organized crime, friends, I will read this. To tackle organized crime and terrorist act, offense of organized crime and terrorist act have been added in the Sanhita with deterrent punishments. Sections 111 and 113 of the BNS 2023 punish the commission, attempt, abetment, conspiracy of organized crimes and terrorist acts respectively. Both the sections also punish the act of being a member of any organized crime syndicate or terrorist organization, harboring or concealing any person who committed any organized crime or terrorist act, and the act of possessing any property derived or obtained from commission of organized crime or terrorist. Sections 111 organized crimes takes care of various state laws enacted in this domain. Section 113 on terrorist act has been drafted on the lines of this UPA. It has also been provided that in the case of the offences, terrorist act offence officer not below the rank of SP will decide whether to register a case under the provisions of BNS of 2023 or UAPA. Friends, this is one of the major amendments, major introduction of the provision, that is organized crime. The organized crime in various spheres, in finances, in the matter of creation of documents in relation to properties, where several persons are indulged, whose identity may not even be known to the police. With this introduction, now the police can certainly rope in all the persons with the charge of organized the commission of an offense, grave offense, against the person or the society. This provision will enable the police to rope in all the persons, and there need not be any doubt with regard to the other person taking a defense in court that I am not directly involved or connected. Though the criminal conspiracy also comes where such an offense has been alleged under IPC. But the definition of the organized crime, since it manifestly evident, where all the persons can be investigated, interrogated, and they can bring home to the guilt of the prosecution's charge. Friends, one of the other important provision, though it is concerning hurt, grievous hurt, the grievous hurt where the act results in the person who has been inflicted with the hurt, which resulting in that person going to vegetative state. The punishment is the inflicted punishment to be up to 7 years. The punishment has been increased. Friends, though the provision under 124A of IPC, that is the offense of sedition, that is not imported into this Act, BNS Act, but other provision on par with 124A in the place of sedition has been incorporated with a rigorous punishment of up a period of 7 years, which can extend up to 10 years. Friends, with regard to the attempt to commit suicide, in fact, earlier also there were some judgments under IPC whether this can't be dealt with, but ultimately the Supreme Court said it is valid. But now under the BNS, attempt to commit suicide has been taken away from the statute, and it is no offense as against the person who commits an attempt to suicide, but the person who is involved, who abets that commission of offense, there is a serious, this offense is put against that person. That is the difference. Friends, with regard to one important aspect which has been introduced in the BNS is culpable homicide, where lynching has been perpetrated against a person. If lynching has been introduced, mob lynching. Mob lynching has been defined, and the punishment in relation to whoever resorts to this offense, a minimum punishment of 7 years has been introduced. Friends, these are the other, there are many other offenses which may not be that much relevant, but the offenses in relation to child, the transgender, and in relation to the definition of a mobile property, which was also to be considered as in relation to intangible properties, and some definitions with regard to the insanity that has been taken out from the statute book of BNS to be in tune with, to avoid that colonial practice of having those words used have been taken out from the present statute. Friends, as far as the IPC is concerned, that is BNS, though there is no the material difference, material change, but certain provisions which have been brought in will cover certain areas which I have just now discussed. And with regard to the friends, some offense relating to women, voyeurism also is made. Voyeurism earlier in IPC it was not there. Now the voyeurism also is made an offense against the person who perpetrates or who commits the offense. And the traffic offenses, hit and run case. Earlier they used to inflict 304A. Now that the offense was made stringently punishable. Earlier it used to be 2 years of punishment. As far as hit and run case, though the statute says that the punishment is up to 10 years, but on account of various furor from the society, civil society, the government has suspended that provision. But as far as causing death by negligent act, by rash and negligent act, which was earlier under 304A, the punishment now under the BNS is increased to 5 years. Friends, essentially, under the BNS, apart from adopting the various penal provisions, certain provisions which I read to you were introduced to bring more stringent action against the offenders, and the government also felt to enhance the penalties. Penalties earlier under the IPC, they were increased. They may not be that much relevant. The penalty of a fine, those have been increased. Friends, under IPC, accepting these aspects and certain other aspects which may not be that much relevant to discuss elaborately, these are the fundamental changes in the BNS. And with regard to the adjective law, friends, CRPC, that is BNSS, Bharatiya Nagarika Suraksha Sanhita 2023. In this, the important aspects as you know, everyone will be concerned whenever a person is involved in a crime. The first right is right to be informed as to why, the reasons for the grounds of arrest. The reasons of grounds of arrest must be informed in writing, but generally the police, they don't inform the grounds of arrest, which will embarrass the accused as to on what grounds he is going to be apprehended. That itself can be one of the grounds for seeking bail before the concerned court, when he is remanded and produced before the court concerned. Now, in the CRPC, friends, as you are aware, CRPC governs the investigation aspects as well as the punishment and the procedures for conduct of the trials. Now, under the BNSS, the significant aspects, though there are many, friends, but I bring it to your notice about the important aspects of the procedural law, which have to be applied in a criminal trial who is charged under the provisions of the BNS. Friends, with regard to the bail, the grounds of arrest, where as you must be definitely knowing the principles laid down by the Supreme Court in the recent past, which is being reminded to the society that the police, even the judiciary, arrest unless you carve out a special exception. The police cannot arrest at all where the offence alleged is below, the punishment prescribed is below the period of 7 years. But in some cases, despite the mandate of the Supreme Court, in tune with the amended provision of the CRPC as well as now the BNSS, when the police are arresting indiscriminately and making out a case, a ground for arrest, the magistrates are not considering to accept the remand and they are relieving. Friends, various provisions have been introduced. I just take your attention to certain provisions where it may be necessary in the matter when a person is arrested, what is his rights and who can be arrested. In section 35(7), who are exempted from arrest is the infirm persons, aged. Age means that is 15 years below, and the person above the age of 60 years are exempted from arrest, unless the Deputy Superintendent of Police concerned authorizes or permits the investigating officer. Such persons cannot be arrested in connection with any offence. More particularly, the offence which is punishable for 3 years and below. Even the judgment of the Supreme Court in Arnesh Kumar's case, popularly known, you must be aware of that. The Supreme Court laid the guidelines not to arrest any person unless it is otherwise warranted. The CRPC, friends, envisaged, that is BNSS, one of the important aspects which you must be aware. If you are a complainant in a case, if you are defrauded, and the proceeds of crime, suppose if he acquires any property, either in our country or abroad, under the procedure envisaged now under the BNSS, the de facto complainant through the police can attach the properties either purchased in India or abroad
this is very salient feature of the BNSS, where the victim is provided with this type of reliefs, which is a very startling feature, and which has to be invoked by the aggrieved party. Such a course was not available. Otherwise, what used to happen is the person who has suffered a loss has to invoke the civil court jurisdiction and seek for a recovery of money or other incidental relief. Now that since the law provides for the, to recover the proceeds of crime and the properties acquired thereof, and the police, now there used to be inordinate delays in the matter of investigation into a particular offense for lack of availability, physical availability of the accused. The CRPC provides the investigating officer to issue the summons or notices for the purposes of interrogation, including recording statements. That is one of the important features which will help in the digital era. Without the support of law, they cannot summon. Therefore, with this introduction of the provision in BNSS, will enable the police to complete the investigation in the prescribed timelines for particular offences. Proclaimed offenders, friends, you must be aware of the proclaimed offenders, who is a person who is unable to be arrested, or after arrest if he doesn't participate in the dispensation system. The procedure envisaged now is that once he is declared as a proclaimed offender, his properties are liable for attachment either in our country or even in abroad. That is one of the significant feature with regard to the declaration of the proclaimed offender by the criminal court concerned. Section 86 of BNSS authorizes a police officer not below the rank of superintendent of police to make a written request to the court to initiate the process of assistance from a court authority in the contracting state. That is a state which has a reciprocal arrangements with our country outside India for identification, attachment and forfeiture of the property belonging to a proclaimed person. Friends, there are many instances where I have come across in pursuit of my legal career where the victims were unable to extend their hands to those persons who have been shifted to abroad, who have become non-resident Indians and set up their lives there with good properties. This provision will envisage that those properties can be certainly attached and put for sale, and the proceeds thereof can be remitted to the victim. This was not there at all earlier. Section 107 of the BNSS, friends, this is the provision where the police, with the permission of the court, to attach and forfeit the property obtained as proceeds of crime. For the first time, such provision for attachment has been made. Just now I have said that. One more, though it may not be relevant, friends, but since amendment has been made, the new provision has been made in BNSS. That is with regard to maintenance of wives, children and parents. Friends, this is one of the important additions in BNSS. Under section 145, in case where the dependent is a mother or a father The proceedings for order of maintenance may be initiated at the place where he or he resides. Earlier, the situation was where the son or daughter used to reside. This is to facilitate these old men to have the redressal of the maintenance wherever they stay. This is one of the best provision for these ailing or old people to initiate the legal process for their maintenance wherever they reside. It's one of the most important aspects so far as the maintenance for those class of persons. Friends, one more important provision, I think you must be aware of this zero FIR. Zero FIR facilitates the victim to approach the police wherever the offense has been committed or wherever there is a threat perception perceived by such victim to lodge the complaint in respect of a cognizable offense, and it is imperative duty of the police wherever whoever he is, the police station manned by such a station house officer bound to register the FIR and later to transfer it to the police having jurisdiction. Earlier also they used to do it, but there was no law. Now that it is mandated by BNSS that look, you go here, there, in the night someone goes, lodges a complaint, they don't immediately, they try to shift their responsibility. Now since it is mandatory and the police are also warned by the Supreme Court in these types of cases, now that since any infraction will entitle the aggrieved party to approach the High Court and seek a direction against the police for initiating an action also against such persons. Since earlier, in respect of a cognizable offense, if it is a cognizable offense, the police are bound to take. Otherwise, they used to just keep it and they don't register. But one of the features in respect of a cognizable offense where punishment is up to a period of 3 years, there is a concept of a preliminary inquiry is introduced. Like this concept of preliminary inquiry, generally they are undertaken by the specialized police agencies like CID, CBI. But whereas now the ordinary police under the penal law, where an offense is alleged against a person under the penal law, that is BNS, they are also entitled to know the truth or otherwise of the complaint, and upon preliminary inquiry they can register. That is one of the important provision enacted. Though certain other provisions have also brought in, there are that much important for the purpose of this meet. And one important provision I would like to just share, because of the most of the cases nowadays, people are relying on the electronic evidence. Every communication sent on WhatsApp or email, if it is offensive or if it corroborates the offense alleged, certainly the police are bound to take that evidence as a documentary evidence, subject to, of course, the certification by the expert in the field. That is now simplified. The procedure in establishing the guilt of an accused through the digital evidence is simplified. One of the important features, I just read that for bringing credibility to investigation, forensic experts have been mandated to visit the crime scene to collect forensic evidence for offences punishable for 7 years or more in section 176(3). The states shall, as far as possible but not later than 5 years, make forensic evidence collection in such cases compulsory. Also, where the forensic facility is not available for the time being, it has been provided that the state government may notify use of such facility in another state. The provision will strengthen evidence collection and bring accountability to investigation, the lack of which today results in lower conviction rate. Several accused used to take these benefits, that it has not been authenticated by identified expert. The forensic science laboratories are also, unless they are notified by the central government, even if such an evidence was given by such a forensic science laboratories, unless notified by the central government, they are not competent to give evidence, certify and give evidence as an expert. Friends, one of the provisions, 193(9), is one of the important provision which prescribes the timeline for conducting further investigation during trial. You are aware in certain offences where the investigation is not complete, but complete in respect of some of the accused, or incomplete in respect of the accused who are put on trial. Yet, if the investigating officer feels that there is a further investigation needed to strengthen the prosecution case, this provision, proviso to section 193(9) provides a timeline for conducting further investigation during trial. It has been provided that after filing of charge sheet, if further investigation is required, it shall be completed within 90 days, and any extension of time period beyond 90 days shall only be with the permission of the court. The provision serves as a safeguard against the potential abuse of the police power, makes the police more accountable, and prevents unnecessary delays in criminal proceedings. The timelines prescribed, the method and the mechanism devised under the new CRPC, that is BNSS, which strengthens the criminal justice system to reinforce the prosecution case, because what everyone's endeavor is only to ensure that the culprit is punished. Why in our country the conviction rate is quite low is because of the lapses in the investigation. Now, under this BNSS Act, the strengthening of the system for the victim and for an early adjudicatory process to secure the punishment of the offender. That is the aim and purport of the government in enacting these three criminal major enactments. Friends, certain provisions which definitely are quite welcoming, and they are in the public interest. They are in public interest, more public interest. But ultimately, the victim, always the duty of the victim is to closely follow till the accused is convicted. Because though at some cases where the Supreme Court time and again was saying earlier, under the earlier laws, why not the judge be proactive in the matter of a criminal case before him? You must be knowing the Jessica Law's case, where a bartender in public was sued by a fellow who was acquitted. And the Supreme Court felt, what is this? And it ordered for reinvestigation. This type of the approach of the police or even the court. The court can be made to act upon the complaint of the victim. That look, this is a defective charge sheet. This is a further investigation is needed. Therefore, he can go and request the court to file an application with the leave of the court, of course, seeking for a further investigation on a particular given point. Friends, these are the provisions which enable, though the law has been laid down by the Supreme Court earlier, these provisions now make mandatory for the police and also the court to eventually see that the accused is bring to the required punishment to be imposed in accordance with law. Friends, as you are aware, the provisions where the offence is committed outside of India, in fact, the extraterritorial operations were also there earlier. Now that also has been strengthened under the BNSS Act, where an offence committed outside of India, if that offence is punishable in accordance with the law of the land, that is BNS. Friends, with regard to the statutory offences and other offences are different, where under the penal law, as you are aware, we are discussing only BNS Act. BNS Act predominantly, as you know, the essential elements of crime, that is the mens rea, the guilty intention, which is not required in relation to the statutory offences, where special enactment, special statute describes. There may not be any mens rea in relation to those offences. An offence is committed outside of India. The country in which the offence is committed, there is no provision to commit that person to trial. Those persons also can be dealt with under the law of the land in respect of the offence committed outside of India. That is clarified under the BNSS. Friends, in respect of certain offences where the citizen directly go to the police, the court, when the police refuses to entertain a complaint, one of the sections, that is section 223. Friend, I'll read this note. Currently, in complaint cases, the court takes cognizance of an offence even without the knowledge of accused person. To strengthen the rights of the citizen, it has been provided in section 223 that the magistrate shall grant an opportunity to the accused person to present his side to the court before the court proceeds to take cognizance of an offence on a complaint. Friends, this is one of the process. A fair process is also embedded under the Act. It is not that the accused is punished just like that. A fair procedure envisaged that a private complaint is before the magistrate. A notice can be issued to the accused, look, this is the complaint against you. Before the cognizance is taken, the fairness in the process is also envisaged. And the protection of the public servants, fine, that is for them. One of the provisions, friends, after the conclusion of the trial, in the investigation, gathering of evidence, recording of statements, collection of evidence, that is mostly the digital evidence, because there were no rules earlier with regard to the digital evidence. That has become made simplified under the BNSS, that where a party relies upon these electronic evidence, a simplified procedure is envisaged, whereby the principal offence committed can be corroborated with these types of evidence with a simplified procedure, that is obtaining the certification by an expert. Earlier it was so tough. Unless it is certified by a notified expert. Notified expert in our country, there were only 9 the state instrumentalities. That is like forensic science laboratories or central forensic science laboratories. They only used to certify. Even out of them, 9 were only certified. Many of the police were not aware, leave alone the citizen. Police themselves were not aware as to how an evidence has to be placed, and its probative value is to be approved by the court. Unless it meets the parameters, it is of no evidence at all. Friends, plea bargaining, though it has been introduced even now under the BNSS, I have hardly seen any plea bargaining, because once a plea bargaining is undertaken, the accused has to be sent to jail with the minimum the prescribed punishment. Therefore, that has not been proved to be a successful attempt on the part of the central government in introducing this. The government thought that the process of plea bargaining will reduce the cases, but it has not been proved to be successful. Friends, as I told you with regard to this examination of the witnesses, 316 of BNSS, in a concerted effort to enhance the seamless integration of technology, Section 308 empowers the examination of the accused through electronic means, specifically utilizing audio-video conferencing facilities accessible if any place designated by the state government. Complementing this, Section 316 stipulates that the signature of an accused who undergoes examination via video conferencing must be obtained within a time frame of 72 hours. This provision underscores a commitment to harnessing technology for efficient legal procedures while maintaining procedural integrity through timely documentation. One of the significant feature of this provision, see how this minimizes lots of time of the court. The persons can, from anywhere in the world, even if an accused is in the prison, the hassle of producing before the court, engaging various infrastructure aspects such as the transportation and their care at the court, this can be avoided, provided this is met. This can be met by the state if this is religiously achieved by the state in implementing, that means in providing the proper infrastructure. One of the other provision, friends, Section 346. To curtail delays resulting from frequent adjournment, Section 346 establishes a framework wherein the court, after considering objections from the opposing party, may grant not more than 2 adjournments when circumstances are genuinely beyond the control of a litigant for reasons to be recorded in writing. Friends, this timeline, 2 adjournments, if it is strictly adhered to, why not the litigant before the court? Why not the prosecutor curb the menace of adjournments? Why not the lawyer curb the menace of adjournments? Therefore, when this substantive provision brought in under the BNSS facilitates the court to insist that yes, you do your job within the timeline frame so that there can be a disposal at the early time. Because what is plaguing us is pendency. Pendency in courts, how to curb the menace is only faster disposal. Faster disposal is the effective implementation of the laws which have brought in like this BNSS. Will certainly the state can achieve, the society can achieve, the people can achieve the justice by enforcing these provisions of law which have brought to us. Friends, these as regards the Evidence Act, now Bharatiya Saksha Adhiniyam. Friends, again the important aspect is giving precedence to this digital evidence. The documentary evidence that has been clearly explained, just I will read a small aspect of it, friends. The definition of documents in section 21D has been expanded to include an electronic or a digital record on emails, server logs, documents on computers, laptop or smartphone messages, websites, cloud, locational evidence, and voicemail messages stored on digital devices. This update acknowledges the shift from traditional paper-based documentation to electronic form of communication and data storage in contemporary India. It helps ensure that the legal system is equipped to handle the cases involving digital evidence. It will provide legal practitioners, law enforcement, and judiciary with a comprehensive framework to deal with the digital evidence stored on various platforms. Friends, these aspects which have been brought in by way of a special provisions in penal law as well as the procedural law and also the Evidence Act, which is very important to establish before a court. In the absence of evidence, proof of which has to be conformed to the provisions of Evidence Act. These three enactments will certainly facilitate the citizen, that is the aggrieved citizen, who are victims. Victim can only be compensated by what has been lost and what injustice has been done, that is by appropriate punishment to be inflicted on the accused. These provisions will certainly enable the state and its instrumentalities to effectively prove the guilt on the part of the accused with these types of evidences, and certain provisions which have been enacted to curb the menace, and these provisions will certainly prevent our philosophy of achieving the object can certainly be happening, and provided all of us works in the direction that will have to help the system. The lawyer has to help the system, the litigant has to help the participate in the system in tune with the provisions of law. Friends, I sincerely thank the organizers for inviting me to give a brief brief on these BNSs. But friends, we may debate on any aspect. I hope that I will be able to definitely answer to any query or question to just clear any doubt on any provisions of this law or any other related criminal law. Thank you, friends. Yes. Yes. Can you enter into the shoes of director? As an advocate general, I can, as in that capacity, any case can be argued. Any case can be argued, that is, it be said under the Constitution. You mean to say, we will not step into the director. Pay attention to my question. Yes. My question is not related to BNSS. Yes. But there are massive exceptions.
We are taking into
Yes.
BNSS.
Yes.
I am Jaikar, Advocate High Court, currently. Thing is, thank you, sir. Thank you, sir. Thing is, there is a public prosecutor who says she has not quoted 321, not 301. So, she is absolving herself without quoting any section, making a frivolous statement that she is representing client and the state. Public prosecutor is the advocate, otherwise called as Minister of Justice. Very few people know that term.
Yes.
Right. True. But she is absolving herself without quoting 321. Now, will you kindly enter into the shoes of more so into Director of Prosecution, who is the legal superior authority in the hierarchy? How can we counter, or if not, allow her not to quit. Force her back into her role. Point number one. Point number two. If so, the reason stated is one, reality is something else. We let her go. Then comes the complainant, informant, himself citing 302, prosecution in person, comes on board. What could be the situation of this person coming in, prosecution in person, can take aid while PP is there, you can take an assistant under the same section 344 of BNSS. Now I will talk also about audio also, that is secondary. But let us limit to this role and responsibility of this PP. Can we take assistant to the 302 person in application? Previously, the law permits, while PP is in action or current role, we can, as an advocate or complainant, being legally aware, also can assist the applicant, but under the supervision of the PP, under guidance of PP. Even an advocate also works under the guidance of the PP. Now PP has gone. We allowed him to go or her to go. Now we have come on board under 302 or 344 of BNS. Can we take another assistant as an advocate? Should be. That is why I asked you to enter into the director of prosecution. Yes. No, sir, your past experience is Advocate General, but I am asking you to come down here in this area. Am I clear, sir? Thank you, sir.
Yeah, thank you very much, sir, for giving awareness on this new laws. So my name is Surya Jidigunta. I'm the FTCCI Energy member. So my question is like, we have got these new laws, but the challenge is on the enforcement of these laws. I mean, if you see, there are so many property disputes and all these things. So are we taking advantage of the, the new tools, technologies in terms of, aiding the law enforcement agencies, just like, the judges, lawyers, to resolve some of these, challenges in terms of property disputes, other crimes, organized crimes, or the financial crimes, economic crimes? There are so many new tools like, GIS, which can give you the boundary demarcation and all those things. So one is the technological updation for the legal system. The second is, justice denied is, justice delayed is justice denied, right? So what is measured can be improved. So if there is let's say a case is being put, how long it is taken for the disposal of this case? That kind of the total time it's taken in the legal cases, so that we will know each case how long it's taking and how do we improve the efficiency of these cases. So that kind of a data, I mean, today any company, corporate, they run on data. So similarly, the legal systems, they should know if they want to improve the system, what time it's taking for the disposal of the cases. That is my second question. And third is there are a lot of challenges in terms of government comes up with these new schemes like LRS and all these things. People apply and absolutely how does a citizen kind of go against the state? So that kind of provisions also, are there anything in these new legal systems? So these are the three questions that I would like you to kind of highlight. Thank you.
Yes, sir. Filing of the cases, the disposal of cases, it depends on the nature of the case that involves time. You have referred to all the branches of law. If a case can be decided in a summary way, which Mr. Pandey is going to debate on the summary suits, but where there are complex issues involved to be decided. Friends, the experience of the country is the pendency of the cases. And a person who goes to court now, he can't have a final redressal. As an interim protection, what he is entitled in law,
to protect his rights intact, and as an interim measure, you will get that interim relief. For main disposal, you may have a better case. The other side, against whom you initiate, may not have a case at all. Therefore, he tries to drag on.
Yes.
But the laws which have been amended, CPC is amended, where the timelines prescribed for completing the pleadings in a time-bound frame. If the pleadings of both the parties, it can resolve the issue immediately, you can resort for either conciliation or file an application to decree the suit forthwith, leaving the contested points to be decided at a later stage. There are various mechanisms provided in law which need to be invoked appropriately. But as far as the pendency of the cases, friend, the court, a court which is dealing with many cases, today at least I'll say about 50 cases have been listed, which are being taken up for trial. Trial means the judge has to conduct the call work. I'm telling about the civil suit. Then he has to take up trials, examination, cross-examination, how much time for one case it takes for him. Then he has to go to next interlocutory arguments or final arguments. If a civil suit is argued, the lawyers may take sufficient time. But this can be minimized where both the parties agree for settlement of disputed questions. Why would every question to be dealt with in the course of trial? We are concerned on one aspect. Other aspects, you please agree.
Settle outside the court.
And pass an interim decree. The Civil Procedure Code prescribes for passing of several decrees in a single suit. But we are poor in implementing. That is the difficulty. If the litigants are fair, the lawyers will be definitely fair. Judge will have nothing to do except to follow the lawyers who will be placing a case before him.
Yeah.
Therefore, the fairness in the system, that is fairness in the litigants, if they come forward, look, the disputed questions we will fight, otherwise you agree. But no one will be ready to agree. That is the human psychology. Friend, therefore, unless there is a change in the approach of the citizen, we may not essentially change the system, that is disposal of the case at early stage. But there are instances where the court, considering the point that will arise for consideration in a given situation or in a given case, they are disposing very fast. But there are suits based on contracts or money cases, and commercial courts are established to deal with the commercial court. In a timeline frame, it has to be disposed of. Matrimonial matters are to be disposed of in 6 months. But the cases are pending for 5 years, even 10 years.
No, I mean, the dispute, land disputes and all these things
Now,
are for 20 years. Sir.
Correct. Now you have said the LRS. You must be aware. Why an LRS? Why do you purchase a property in an unapproved layout? Because the citizen, if he goes for approved layout, the price is so much. The Supreme Court has condemned all the states in the country. Don't introduce this LRS scheme. Now, sir, this is the last chance. Give last chance. Because there is other agenda where these persons collection of this money will be utilized by the state government for other
funding and all.
This is happening. This LRS, in fact, the matter is seized by the Supreme Court. This government also has hastened up the process of LRS, but the matter is seized by the Supreme Court not to entertain the process of this land regularization scheme, because it is not in tune with the laws applicable. It doesn't meet the requirements prescribed by the HMDA or the other local body. Therefore, LRS, suppose if the citizen is willing to accept the offer of the government, they can pay and get it regularized so that some validity is there for his plot. He will enjoy, get a construction, or obtain a loan.
Why instead of he registering a plot purchase in a unapproval?
Sir, for the benefit of all, let's take the question and answers after the second session. It's getting delayed. Sir, thank you for that wonderful session. And I just have one small question. We had been grown up listening to our grandparents saying that padega nahi to 420 banega kya? Is that section still there? So let's move on to the captivating and compelling session, which you all will love. Our next speaker is Mr. Nirmal Kumar Pandey, the founding partner of Lex Arjava LLP. Nirmal did his LLB from Calcutta University and LLM from Osmania University, Hyderabad. He got enrolled before the Bar Council of West Bengal in 1987 and subsequently transferred his enrollment to Bar Council of Telangana. Initially, he joined his father's chamber in Kolkata, and subsequently he moved to a solicitor firm, namely Ghosh and Company, Kolkata, and got exposure in various types of litigation, civil, criminal, labor, limited taxation cases. Thereafter, he got an opportunity to be associated with big conglomerates and TCI Limited and Gati Group, having more than 25 group companies diversified into various business activities as legal advisor. During the said association, he has handled transactions, corporate litigation matters, pan-India, joint ventures, strategic alliance, mergers, and demergers. He is an active member of Telangana High Court and Supreme Court of India. In 2018-19, he has floated a law firm by name Lex Arjava LLP with the help of support of his esteemed colleagues, which are 7 partners pan-India with a workforce of 30 members. Today, he will take us through the summary suit under the code CPC, a faster way to recover critical receivables. So, over to you, sir.
Good evening to all of you. I think 5:10 to 6 now. Anyway, I will try to sum it up. It is nothing new here. My learned senior friend has talked about the old IPC, CRPC, Evidence Act, BNSS, BNS, and BSA. I am not going to talk anything new here, because this order remains in the CPC. Everybody knows. All the lawyers, even non-lawyers also might be knowing out of their experience. I did something on my own. I do experiment, of course, all the time, every time. And believe me, there are so many cases. When I was representing one of the listed entity called TCI Finance Limited, I will give the name also. More than 1,300 cases were filed here in Hyderabad. 1,300 plus cases, a team of 20 people. And when I came here, the people say, I filed the cases, I filed the case, I filed the case. Big, voluminous records and files and all, I was discussing with one of my friends. I said, why this regular suits, which goes on and on and on for about 4 years, 5 years and all this? Why not we go for a summary suit when there is a provision envisaged in the CPC? Why don't you go for it? He says, sir, we need to come out from the comfort zone. Everybody knows that. It's nothing like some rocket science is there in Order 37. Everybody knew this. I don't want to give the name and all. A very renowned advocate here. He said, Mr. Pandey, it's very difficult to convince the court for a summary suit. They themselves are not aware. They are aware, even if they are aware, they are comfortable with the regular suit. I said, Mr. Reddy, let us go ahead and file some summary suit. And believe me, same place, same courts, Secunderabad, Hyderabad, Rangareddy or whatever it is. The cases were concluded from trial court to high court to Supreme Court. I will give a citation also. Within 9 months. 9 months. I will give a citation to you up to Supreme Court. Of course, we went there or the great legal luminaries, Prabhasankar Misra, he was opposing us in the court. And I engaged Arun Jaitley at that time by paying 33,000 rupees. I have the bill also, just for the sake of it. I'm talking about 1998-99. Long ago, you know. I kept the bill so that people say that he's charging 10 lakhs, 5 lakhs, 18 lakhs and all. I said that I paid this much. And you believe me, they say that the basic purpose of this cases, you know, all this, what is called promissory note, hundi, bill of exchange, return contract, guarantee and all, will get lost. Why I should face this music for about 4 or 5 years, you know, and judges appreciated and they concluded this very clearly in an unequivocal term that summary suit must be appreciated by one and all. Then we said that having got some good experience and all, we said that let us see how we can do it. So I filed not less than 70-80 cases here. And for this company, what I named just now, it's a matter of record. I don't want to exaggerate anything. I think around 170 crores were received because a huge 1,200 cases, big company, big corporate. It was not a disbursement of loan, it was a distribution of loan, let me tell you. With left and right, the people signed the paper, say 36% interest, 48% interest. I said, who pays? I have not seen that so far that somebody pays 36%, 48%. No, but the people signed, they took the loan. But recovery was the biggest challenge. And friends, I'm not exaggerating again, and I don't want to. But it was a good experience going through the process of the summary suit, you know. And summary suit is the most efficacious and effective remedy to recover your debts on some grounds of this hundi, bill of exchange, as you know, all, it's nothing new. You know, negotiable instrument is what it says, right? All negotiable, including a written contract. And believe me, thereafter, for me, at least in my law firm, I never go for a regular suit at all. It is only Order 37 I invoke. And not only is a plain vanilla, we go for attachment before judgment. We go for 39 Rule 1 and 2, 38 Rule 5, 39 Rule 1 and 2 also. And we go for arrest also. So 3 petitions we file in all. 2 notice will go in 1, we get some interim order. So that is a strategy, very strategical. And this we are doing now with other clients also. It is very effective, please believe me. You know, and I found it to be very good because I went to the extent of seeing the legislative intent behind introducing this summary suit. And let me tell you, I think who is doing this changes and all? Just change here. Very important, just to see this. The legislative intent behind the summary suit stems from the commercial law principle that business transaction requires certainty and speed in enforcement. Somebody, my colleague, I think my friend was telling, is speed in enforcement. We have everything here, but there's no enforcement. But if you go to other countries, this is strict enforcement. Whatever is written, even my friend also is here from High Court, this thing. We have so many laws here, but no enforcement. But for the weak enforcement, we don't get the desired result. So now we say, the procedure acknowledges that in commercial dealings, particularly those involving negotiable instrument, the liability is often clear and undisputed. Therefore, allowing defendant to prolong litigation through technical or frivolous defenses would undermine commercial confidence and impede trade. That was the intention behind enacting this provision of Order 37. And the basic purpose gets defeated today because we go in a traditional mode of recovery. That is not going to happen. At least for negotiable instrument, my request to all of you, you are all very intellectual and you know everything out of your intention, even if you are not an advocate. So summary suit is one of the most efficacious remedy to recover your money for all the negotiable instruments. Now, when a summary suit can be filed, I will not go through all this. It is bill of exchange, hundi promissory note on a basis of a written contract. It is not only check, bill of exchange, promissory note and hundi, even a written contract also it can be filed. You know, sir, one second, sir. I will come to the question and answer. Just let me run through it. It's hardly limited slides. On a guarantee and by assignee of a receivable. This is recently just last month only. The debt was assigned by A in favor of B without any consideration. Again, I'm repeating, no consideration, assigned. There may be some internal understanding. And I think it's hardly 6-7 months. We succeeded. Attachment before judgment we got it. Property was not developed. Then they came forward, say that I don't have liquidated money and all, cash and all. I will give you some land to you in Samirpet. He said, fair enough. Give the land. Land was, the decree was passed, land was registered and all. So we did it. Now the difference between a regular suit and summary suit, as you all, I think, may be aware or may not be aware, is only you have to write that it is filed under 37, immediately below the cost item, and plaint must contain a statement that no relief has been claimed outside the scope of 37. You cannot parallelly run the show and say that here also you want summary and somewhere also you want. So you must write in the paragraph the cause of jurisdiction, etc. These are the basic procedure. These are the procedure filed. See, actually, to be very frank with you, if you follow this properly, the procedure, I can tell you, I cannot guarantee you, nobody can guarantee in the law, but within 6 to 9 months, I've seen that 6 to 9 months, you can get a decree for any amount. And that is well tested, proven by our law firm, or even when I was a legal advisor. I have done this myself and we recovered huge money from all the people, huge money. This is very, very provided your judgment debtor and all, he is solvent. If he is not solvent, he is a sinking boat and all, and nothing is there, you cannot do anything. But if it is there, believe me, this works very, very good, the summary suit. For any critical recovery, for any amount, that is absolutely, you can safely go and invoke this order 37. And you know this 10 days, that's what we say in the summary suit. Summons served, 10 days appearance. File summons for judgment, leave to defend 10 days. Leave to defend is granted, it becomes a regular suit. If it is not granted, it becomes a summary suit. In summary suit, they decree the case within 2 to 3 months. Max. If you go by 10 days process, of course, but sometimes it takes delay. So entire decree can be passed. If leave to defend is granted, because see what happened, very catch here. For the sake of raising dispute, other side raising dispute, and say that it requires full-fledged trial. So once you go to the witness box, documentary evidence, your oral evidence and other things. But again, if there is a confirmation of debt, that is called in the month of March, most of you must be aware, in the month of March and 31st March, they take a balance confirmation certificate. As on date, this much due is pending. That is an admission. Based on that, suppose if the 100 rupees suit you are filing summary suit, he says 80 rupees is pending on 31st March. 20 rupees is disputed. So to the extent of 80, it can be a summary suit and 20 can be converted into a regular suit which requires full-fledged trial. So 80 you must deposit, I will withdraw, and 20 can be converted into regular suit. That has happened in so many cases. So at least 70-80% you get the money through this process, provided your documents are robust. Robust means you must have an admission on their part. Because everybody wants to raise dispute for the sake of raising dispute to come out from the clutches of summary suit. As like winding up proceedings and all, you must be remembering on Companies Act. The people do it, but if you really follow this process, you can certainly recover your hard-earned money, which should not be squandered away by any means. It is a hard-earned money. So this is found to be very effective, sir. Since I have applied this and I'm still applying for all the negotiable instrument and all, it's very good. Now again, leave to defend and all. Leave to defend is what? I have some dispute. I want to defend the suit. It cannot be summarily decided, like what my learned friend was telling. Something can be decided summarily, something requires some full-fledged trial, full-blown trial in the court. There are a lot of witnesses come in the witness box and write this, that, and all. So many things are there. So, if for a part of the amount it can be converted into a regular suit under section 26 or order 7 and all, then it's fine, that can be done. But at least I will get 80-70% of my money. And if fight it out for another 1 year, 2 years, then no problem. So this is the way as to how we have to deal with this. So again, 10 days process is there, counter filing this, that, and all. Important aspect to monitor summary suit is observe the date of service of someone, so that after the expiry of so 10 days is a beauty of 10 days. There is no dates as such. So you have to follow 10 days. When the date has he appeared, not appeared, then file that he has not appeared, then case can be decreed. And cases were decreed here. Once a leave to defend is allowed, once it is allowed, then it becomes a regular suit. Then they can go to High Court, we can go to High Court, the plaintiff can go to High Court and say that no, this was admitted amount, this can be done. So many things are there, but if there are so many issues to be resolved through a trial, it cannot be remain as a summary suit. But clean case, clear-cut case, admitted amount, only the problem is the people don't file the summary suit because of the court fees. So everybody says, sir, 138, check this on case, file check this on case or not. But due to some reason, if check this on a case gets dismissed on some technical reason, then by the time your limitation goes, and when limitation goes, you cannot file summary suit. So I advise at that time to our client, PCA Finance only filed 1200, 1300, 1400 cases here. Go parallelly. Don't worry about the small the court fee, which is the lowest in our state. That is 1% plus 5,330 and all, whatever it is. In other places and all, it is 7%, 8%, 6%, 4%. So why the money was recovered? So much money was recovered because they filed 138 and this summary suit parallelly. And this suits and all is a slow poison. 138 and all can go on technical point and all, but this will not. This goes up to Supreme Court and all. And suppose in check dishonor, as you know, party comes and pays some small money. Out of 10 lakhs, he comes and pay 1 lakh rupees. Say that I will replace the check. This has happened in one case called Jaswal Granite. Again, it went to Supreme Court. 1 lakh rupees was paid. He didn't replace the check for 9 lakhs. He said, I will come tomorrow, day after, and all. Thereafter, the client filed the case, though he demanded 9 lakh rupees in the notice. But court said that no, it's a defective notice. Because there is no, you cannot present a check of 10 lakhs when he has already paid 1 lakh. So when is the old new check? There's no new check. So it was in a very nascent stage. Every day some new judgment used to come. Case gone. You won't believe, after 10 years, the civil case paid the entire dividend. When we went for EP, filing of EP, taking the decree, filed an EP, attach the property, go for a sale, come forward for settlement. Even today, before coming here and there was some this thing. Today, filed EP in 2001. Today, in which year we are in? 25. One of the client, one of the parties want to buy the property. He approached and say, sir, tell me how to buy the property. The defendant has been vanished. He is not available. Notice sent so many times, nothing is there. We are going for a substituted service, of course, to publish in the newspaper. Nothing happened. But now the new buyer says in Bachupalli, he says, sir, I want to buy the property. What is the way out? I could see that there is some order here. I said that, sir, what we can do is we can go to the court and say that let the property be auctioned. And you come and become a bidder. If you are a highest bidder, you can get the property. pay that money to us, our client, TCA Finance. Take that property, there's no other problem. So that lawyer came. What I mean to say, 24 long years. Even the client forgot. On yesterday I said, sir, there is something is there. Sir, let's have a meeting in hotel and all. That both the lawyers are coming and let's have a meeting. So what I mean to say, this is a long drawn litigation. You know, it is there. It was a normal suit and all, of course. Normal suit filed, got a decree, filed an EP, defendant disappeared. Is going on and on. Everybody forgot it. Even the client also forgot it. But suddenly, when somebody came to purchase the property, he found that there is an EP pending. I should not buy the property, you know. So he came for it. Now he said that I will pay the money to you. I want to buy. Defendant is not there. Respondent is not there. So this does happen, you know, does happen. So what I mean to say is, this monitoring of this summary suit is very, very important. Our office, of course, my colleagues are there. They file and they have become expert. They're nothing all expert in this filing, but this is nothing new. But the result is very good, and we request all of you, since it's an education session, I don't want to say anything. Out of our experience only, we advise that for any negotiable instrument, don't go for a regular suit. And when you file a suit for recovery, do something new. What is new? Attachment before judgment, injunction, or arrest of the person. Arrest means civil arrest as contemplated in CPC. So this is how it has happened. And if any question and all, certainly I will take it up. Thank you very much. And I must thank to our organizer, Mr. Ravi Kumar, Mr. Nareshan Gilli, Mr. KK Maheshwari, Mr. Tasneem Sharif, and all the other office bearer of this FTCCI for giving an opportunity to say something about this.
Thank you, sir. We'll take few questions and answers. During the tea break also you can have a discussion with them.
Both, sir. Both.
Your question.
I'm not expert in criminal law.
The overlap of civil disobedience.
That is called civil arrest. There is something called civil arrest in CPC. Yes. Correct.
Now comes our vacate the person. The civil dispute. Order decreed in 94. Again, the mistake. Thank you. Anyway, I think I'm audible.
Yeah, you are audible.
Decree, order is 1994. The same offense committed. Repeated offender or proclaimed offender.
Let's take it offline.
Yeah, take it offline, sir.
Take it offline.
Sir, here.
It is a general question for everybody.
Yeah.
It is the enlightenment for the rest of the public.
Oh, very good.
Yeah.
Maybe including yours.
Fugitive offender. Called fugitive offender.
No, sir. Proclaimed offender. Fugitive offender ban gaya. You are right. Now thing is, he has repeated and court is not giving, when it crosses the border of from civil to criminal, it is not, this criminal court is not accepting him as a repeated offender or proclaimed offender, while the advocate is pressing that you open up a rowdy sheet and make him proclaimed offender, not taking. So, pardon me for little adjectives, greasing of palms, slippery of justice. Currently, we are in Bharat.
Sir, we don't want to discuss here.
No, sir. I limit to Madam tell 1 minute only. But I am giving a hint.
Thank you for your question, sir.
Yeah. 1 minute.
Question is not complicated.
No. It is.
We'll take it offline, sir.
Start provoking, I'll finish.
So there's a rain warning from.
Let the question incubate. My question, other question, how to bring back the PP is incubating in sir's thought process. So the point is, this overlap of civil into criminal, how to bring them into order, and 90 days is also acting as a sword of Damocles on their heads. Two cases are running parallelly, criminal as well as civil. Now, how to force? Because I told two adjectives, postponements, adjournments. While Mr. Jayakar is fighting and educating both the judges. Educating. No, you need not enlighten. Sir, madam, this is what. So now, let this incubate, think and tell me, Order 39, Rule 2A, how to bring them in force, and I am going to file a writ if they are not accepting. A last judgment, hearing was just yesterday. I told, if you are not giving me proper direction, I am forced to file a writ and get a direction that you finish adjudication process within 15 days. Am I fair? Thank you. Thank you.
Thank you, sir. We would like to give mementos as a gesture to our speakers. Naresh, sir, please. Ritesh, please. Sir.
Thank you. Thank you.
I now request Senior VP to give away the vote of thanks.
Good evening, everybody. Shri Shivananda Prasad, former Advocate General, Telangana and designated Senior Advocate. Shri Nirmal Kumar Pandey. Shri Ravi Kumar, President FTCCI. Shri Naresh Chandragelli, Chair Corporate Law. Srimati C.S. Tasneem Sharif, Co-Chair Corporate Law. At the outset, I thank Vandi Shivananda Prasad on the awareness program on newly enacted criminal major acts, BNS, BNSS, BSA 2024 in the administration of criminal justice system. The key reforms there are digital evidence has been prioritized, simplified rules for admissibility, modern standards for electronic records, expanding the definition of the term document. I could also look into many terms like zero FIR that has been used. Besides law being made stricter to ensure that there are more convictions. And Shri Nirmal Kumar Pandey spoke on the recovery of receivables, discussion on summary suit, and more to expedite the process. I never knew that a summary suit could be so effective so as to complete the whole process in months. And even a summary suit can be broken into two parts, a summary suit and a recovery suit. And at least to the extent that there is clarity that amount is due and it is admissible, to that extent the money can come immediately. I'm sure that people who have been attending this program over here would be benefited from the knowledge that he has imparted in the summary suit that can be initiated for negotiable instruments.
This program would not have been possible without the tireless efforts of the organizing committee led by the Corporate Law, IBC and ADR committee. Your commitment and attention to detail have ensured the seamless execution of the event. Finally, a big thanks to all the attendees for your active participation and engaging questions during the Q&A session. Maybe for some time, I thought it was the court hall where more technical than general. As we conclude, I encourage all of you to carry forward the insights gained today and continue contributing actively to the evolving landscape of criminal justice in our country. Thank you, sir. Thank you for your